So in Minnesota, there are actually three different types of probates. There is informal probate, and then there's formal unsupervised probate, and then there's formal supervised probate. And when starting out the probate process, it's really important that you open probate in the correct type of probate. Informal probate is reserved for very straightforward situations. You don't want to have minor beneficiaries. You don't want to have any complicating circumstances. Oftentimes, you don't want to have a lost will where you only have the photocopy of the will. There needs to be no ambiguities in the will that need to be resolved. So oftentimes, informal probate is reserved for probates that are small and straightforward and have adult beneficiaries. And in this case, with informal probate, it's debatable on if you should go through informal if there's real estate in the estate, because when you open it informally, there are rules on how quickly you can sell real estate in informal probate. Whereas when you open it formal, unsupervised, as soon as the personal representative is appointed after the hearing, they can sell any real estate, whereas there is some restrictions on the timeline with informal. So formal supervised is oftentimes reserved for situations where maybe there's real estate that needs to be sold in the estate, maybe there's minor beneficiaries. Those are all things that might kick it into formal supervised. In this circumstance, there is a court hearing that appoints the personal representative to act on the estate. So you do have a court hearing. Right now in Olmsted County, Minnesota, they're occurring over Zoom. That's pretty convenient for folks if they don't live here. And if the paperwork is in order and nobody contests, generally speaking, the judge will sign paperwork to appoint the personal representative. And then at that point, the personal representative can begin collecting the assets, but at that point, you don't necessarily have to have another court hearing to sell real estate, to close the probate. You just usually have one court hearing unless more complicating factors ensue later on, okay? And then the third type of probate is the most formal. It's called the formal supervised. And this can happen in many different situations that are more complex. So for example, let's say the estate is insolvent, meaning the debts are bigger than the assets of the estate. That's something that will kick the probate into formal supervised. This could also happen if the will the will isn't written clearly, and so there's some ambiguity on who owned what. We had to do a formal supervised one time when we had a fire and the home was owned by husband, wife in a blended marriage, and it was hard with the insurance proceeds. It was hard to know what was his and hers property, and nobody got along with the kids. And so we really needed the court to mandate, okay, this percentage of the insurance check was part of the estate, and this part is part of the surviving spouse's assets. So those are reasons that might kick it into formal supervised. When you have a formal supervised probate, it means that the court will be supervising it even after the opening. So later on, when you go to sell property or close the administration, there's going to be further court hearings to get the actions of the personal representative approved. Now, it is more protection for the personal representative to have the court oversee the actions of a personal representative and bless them and say that they're in agreement that they did it correctly. However, it can really increase legal fees and can make it take much longer to administer the estate. So if there isn't those complicating factors, most people will oftentimes prefer to go formal unsupervised or informal probate. Thanks so much for listening.